dear Madam K.K. Singh sir. So our main motto is that what we are the first generation lawyer and we started from the consultation room only. We know very well what the problems of the new generation as well as the people those who are not having the infrastructure, what the problem they are facing. So in order to mitigate that problem, we started this lecture series. The motto is that to learn and let others learn. So in this lectures group, we are taking the nomenclatures of Delhi High Courts, and one lecture is of the civil side and another lecture is on the criminal side. So today is the civil side lectures. Another the last week's lecture of the criminal side, the criminal appeal was there. Today is the suit only. So we have the invited as our best capability, the best lawyer of Delhi High Court, those who work in the civil side, as a civil side and original side, and we will be listening about them, the how this the civil CSOS are being filed in the Delhi High Court, and what is the ingredients are there, and what is the legal law point to be taken care of while drafting a suit in order to get the notice admitted, the maintaining the pecuniary jurisdiction as well as the territorial jurisdictions as well as the other lacunas, everything they will be enlightening us on over that issue. With that, I am really grateful that the large number of people are has attended today's meeting, but so many people has missed out. I think they will be coming. And with that words, I will be now handing the mic to our senior group member, coordinator, Mr. Prashant Vermaji, to carry on with this program. Thank you, sir.
Thank you, Najib ji. As all of us knows that with a small group we had initiated with our consultancy lawyers, those who are usually having our lecture series on each Friday. If it is not, then the next Friday. Sometimes because of some holidays also we face difficulty. Otherwise, we are continuously working for last 6 months. Today is the 11th lecture, and today's subject is civil suit original side. We are fortunate that in our Delhi High Court, like some other High Court, those who have got the original side. In Delhi High Court, original side, we have the civil suit which is being filed with the nomenclature CSOS. We are dealing with this nomenclature wise because the young lawyers must know when they are coming to the court that what are these nomenclatures and what for, and under that nomenclature what are the things which are being dealt with and how the cases are being proceeded with. So civil suit is a suit wherein the civil rights is being executed by the parties before the court sometimes, whether you are as a plaintiff or as a defendant also, you are defending or also filing the counterclaim. So primarily we will be dealing on those parts. One is when we are filing the civil suit, first is the plaint, then the written statement, then replication, and whatever the counterclaim, if it is counterclaim, then the written statement to counterclaim. Thereafter, we proceed further for admission denial of matters. Then the issues are being framed by the court. Then plaintiff's evidence and defendant's evidence. While drafting a plaint also, what are the main aspects which are important? When you are filing a plaint, when you are preparing or drafting a plaint, you require to add the documents also, that is list of documents, along with the list of reliances which we used to also rely upon and file also. There are affidavit of evidence which comes later point of time when we reach to the evidence level. So after the evidence is over, then the matter straight away listed before the courts for arguments, finally to be argued on the civil suit, which is followed by a decree also. Decree is also being passed. Till up to that level, we will be discussing on today's lecture. So we are fortunate that we have got the prominent lawyers, lawyer friends, those who are dealing in all these aspects. Mr. Rashid Azam is an AOR from Supreme Court. He is with us. We are also thankful that Mr. Jayasankar, who is also an advocate, is also a practicing lawyer of Delhi High Court, as well as is a regular member of our consultancy room, lawyers. Apart from that, Ashok Gundani is one of the prominent senior lawyer in the civil side, and we have seen his practice and the nature for last decades, I can say. Similarly, we are very fortunate to have the chief speaker, who is Mr. Ashok Kumar Singh, the senior advocate. So he will be also having their feelings. But we have, while discussing all this, we had also thought of asking our friends to who will be in which part. So they will be primarily saying so. So I will be now requesting Mr. Rashid Azam Awad, who is who will be putting stress on the documents part in a civil suit. So I will request Mr. Rashid ji to have his own words on this civil suit original check.
I think I can do it without. So, respected Mr. Prashant Verma, who is my senior and was groomed us here in the consultation room for a long time now, and then Mr. Singh, senior advocate, Mr. Gurnani, senior, and Jai Shankarji, my seniors on the other side, and my friends and colleagues. Of course, we have a very niche area to discuss here, that is about pleadings and documents. So as Mr. Verma pointed out, the category of suits, which is the nomenclature is CSOS, Civil Suit Original Side. So original side is, when you actually hear original side, you don't see this nomenclature in the district courts, but then you see it in appellate forums like Supreme Court and the High Court. So while that is original side, it could have gone to the should unless there is a rules 2008 and read with the Delhi High Court Amendment 2000, Delhi High Court Act Amendment 15. The threshold for filing original was raised to 2 crores. And by that, what happened is any suit that was undervalued to 2 crores had to lie before the district. That actually are beyond the scope to the litigation that you normally don't see in the district courts. You will see they're delayed for decades, they are not decided. So case management rigor, which is actually an important feature if you see the Commercial Courts Act, it has actually introduced the rigor of the case management so that the suits can be decided in a time-bound manner. So the same has been adopted in the Delhi High Court original side rules for dealing with case with original side jurisdiction. So what they require is the pleadings have to be in a certain way so that most of the clutter is actually filtered out even before the issues are framed. So normally you would not see these features like admission and denial of documents and statement of truth. These are important documents that actually feature original side jurisdiction of the Delhi High Court civil suits. So what we see is if we actually see how the documents and the pleadings are filed before the High Court, they actually have to be filed in 5 different folios, which forms part 1, part 2, part 3, part 4, and part 5. Part 1 would include the plaint, which is the core document of the claim of the plaintiff. And then based on that, they would have to file a statement of truth as well, which is mandatory. Without that, because the earlier, if you talk about the normal suits filed in the districts, they would actually only require, under Order 6, they would require a verification line to be added under the suit, that these are the parts of the facts that I actually have full knowledge about, and rest are legal things that I have belief in. That's what we actually put in and categorize the paragraphs from 1 to 30 and 30 to 31 to whatever may be the case. In the same way, but then statement of truth actually needs larger details, more precise and nuanced details, which actually bring in more truth into your pleadings. You can't get away with what you plead in the statement of truth. That is an essential thing coupled with the pleading. Then, after the plaint and the statement of truth is brought before the defendant, after they come before when the summons is served, they have to reply to the plaint. So what they do is they have to file a defense statement, and that defense statement filing has to be done in a very time-bound manner, which is 30 days. Even in districts, if you see, the limitation for filing written statements under Order 8 requires that you have to file it within 30 days. So if you actually exceed the 30 days, then you have to explain, sufficient cause has to be given why it has to be condoned, and you can still be allowed to file it extended up to 120 days. However, that is largely not as strict as it is in the original side before the High Court. It is more laxed, lenient in the districts, but when it comes to the original side in the High Court, the rule is very concrete and etched in the wall of 120 days. Once you reach 120 days, your very defense would be struck off if you fail to file your written statement. And supposedly, if you file a written statement on day 120 and seek a condonation, and there happens to be a defect, and to remove that defect, you have to step into the 121st day, your defense even then is struck off. Because the High Court rules in general actually allows you to cure defects in your pleadings in 30 days of the original first filing. If you exceed 30 days, you cannot, you have to seek a condonation of refiling, delay in refiling. But then here, the moment you step in on day number 121, your defense is gone as a defendant. So there are judgments that actually govern it. Now we will also just go on detailing the parts that we are dealing with. We will on part 1, which actually forms the plaint, the written statement, the replication. Replication is actually a regular right rather than a discretionary right when you actually talk about other jurisdictions in civil suits. Here, you will get a right to file replication. For that too, there is a limitation, which is 30 days. And then there is a grace of 15 days, so 45 days is what you can take at the most. After that, you will not be able to file your replication. So this forms your part 1. Part 2 would have all interlocutory applications, like application for stay and securing assets, etc. All that would come under part 2. And in part 3, you would have documents. Now this is very important, documents, which is part 3. When you actually file documents, these would be filed along with the plaint, but then they will form a part of folio 3, which is part 3. And there would also lie when you file documents as a defendant in your written statement, it will go to the same part 3, but then it would have to be coupled with an admission and denial affidavit qua the documents that have been filed by the plaintiff, stating whether you admit those documents or you deny those documents. If you don't actually file a written statement along with the admission and denial affidavit, your written statement itself may not be taken on. The word is not may, it will not be taken on. Now part 4 actually forms the evidence part, where we actually lead evidence by way of affidavit. So that's where we will actually have the affidavits, and then the exhibits would all be mentioned there. And those will be related with this part 3, the document part. And you will lead and produce your evidence and try to prove your case. Then there is a miscellaneous section. The miscellaneous section would have other documents like wakalatnama, etc., which are not very much relevant to the material. So this forms majorly the documents that we inspect. These will be in folios 1. So you should know when you actually, supposedly you go in the file and check it and argue, then those would be in these parts. This is good to familiarize as well as to how the records are maintained, and yes, this is far more organized than what it is usually in the districts. And the case management rigor actually brings a lot of velocity into the litigation. Normally is absent. We are notoriously known for this, that cases are pending, crores of cases are pending, districts, this and that. We are so used to hearing all that. This is a remedy, actually an effort and a remedy to get away with the pending case dependencies. At least the new ones would actually not be prolonged years. So this was about the document. I asked to confine it, and I think that will be helpful. Thank you for your time.
I indeed the basics of how we have been finding the civil suits in Delhi High Court. We further going forward with Mr. Jason, okay?
First of all, we warm welcome of our Chief Speaker and then other speaker. I also congratulate and thankful to our coordinator committee members and other citizen, our councils or my associates and other members. मैं हिंदी इंग्लिश दोनों में बोलूँगा। हमने कोऑर्डिनेट कमेटी के हमारे सीनियर मेंबर उन्होंने बताया कि सूट की प्रक्रिया क्या होती है। प्लान आता है, रिटर्न स्टेटमेंट आता है, एप्लीकेशन आता है, इशू टाइम होते हैं, उसके बाद में एविडेंस होते हैं और जजमेंट डिक्री होने के बाद एग्जीक्यूशन होता है। उसके बाद लॉ, प्रोसीजर एंड प्रैक्टिस, प्रोसीजर और प्रैक्टिस, व्हाट शुड द प्रोसीजर एंड प्रैक्टिस, इस ओवरव्यू को बड़े अच्छे तरीके से हमारे ओवर साहब ने बताया है कि कैसा प्रोसीजर होना चाहिए। अब मैं तो जैसा कि शुरू में ही हमारे कोऑर्डिनेटर सब ने बताया था, एज ए प्रैक्टिसिंग एडवोकेट सिविल में तो मेरा बहुत वो नहीं है, लेकिन जो नॉर्मल चीज़ें हैं जैसे व्हाई शुड आई फाइल ए सिविल सूट, सर ने बताया था कि लीगल राइट इन्फ्रिंज हो। अब एक मैक्सिम है, वो लैटिन मैक्सिम है, यू वी जस्ट वी रेमेडियम, वेयर देयर इज ए राइट देयर इज ए रेमेडी। अब व्हाट इज द राइट, अब सेक्शन 9 सीपीसी का बड़ा क्लियर है कि लीगल राइट, लीगल राइट में कौन से, सिविल राइट। अब दो प्रकार के राइट होते हैं, सिविल राइट और सिमिलर टू सिविल राइट। when your civil right has been violated or infringed by the another person, you can file the suit, appropriate remedy seek under this procedure. अब बेसिकली जो ओरिजिनल साइड है, वैसे तो हमें लोअर कोर्ट में जाना चाहिए, सेक्शन 15 कहता है नीचे से जो भी लोअर डिग्री का कोर्ट होगा वहाँ का टेरिटोरियल जो भी होगा, प्रॉपर्टी सिचुएटेड होगी वहीं हम फाइल करेंगे। ओरिजिनल साइड क्या है, कलकत्ता, मद्रास, बॉम्बे, दिल्ली और सम लिमिटेड ज्यूरिडिक्शन हैदराबाद, इनको एज ए ओरिजिनल ज्यूरिडिक्शन के तहत एक आप डायरेक्ट, जैसे कोर्ट इज फर्स्ट इंस्टेंस, आप वहाँ फाइल कर सकते हैं। अदरवाइज अन्य हाई कोर्ट में जो 24 हाई कोर्ट है, एज ए फर्स्ट इंस्टेंस हम सूट फाइल नहीं कर सकते, एक्सेप्ट कि अगर यूनियन का मैटर स्टेट का है तो हम सीधे सुप्रीम कोर्ट में जा सकते हैं। लेकिन यहाँ सिविल राइट ऑफ इंडिविजुअल पर्सन when violated then we approach before the court। अगर हमारा पेकुनरी जुरिडिक्शन 2 करोड़ का है और उससे अधिक है तो हम सीधे हाई कोर्ट में अप्रोच कर सकते हैं, 2 करोड़ से ऊपर का है। अब हमें जो मेरे पास एज पर नॉलेज है वो मैं बताना चाहता हूँ। मेन इशू इसमें कॉज ऑफ एक्शन, हाउ कैन आई डिटरमिन द कॉज ऑफ एक्शन। फिर से हमारी चीज, क्योंकि पेंडोरा बॉक्स है, कॉज ऑफ एक्शन कैसे डिसाइड होगा कि कब एराइज हुआ है, उसके बाद में लिमिटेशन तुरंत स्टार्ट हो जाता है। अब सूट हमारा पार्टीशन इन नेचर का है कि पोजीशन इन नेचर का, कई तरह, अब तो आईपीआर और अपना कॉमर्शियल में भी उनके अलग अलग प्रैक्टिस और प्रोसीजर हैं। तो कॉज ऑफ एक्शन क्या है, ये हमें अपने प्लांट में क्लियरली शो करना पड़ेगा। सेकंड ज्यूरिडिक्शन क्या है और लिमिटेशन, इसके साथ साथ कोर्ट फीस, और जो सबसे बड़ी चीज आई है सलेम बार एसोसिएशन जजमेंट से, वेरिफिकेशन ऑफ द प्लान। अगर वेरिफिकेशन नहीं है और बाकी सब चीजें दिखाई हैं तब भी हमारा सूट एज ए रिजेक्ट हो सकता है, जो 711 की कंडीशंस हैं, या रिटर्न कर सकते हैं, जैसा आपकी कृपा है कि भाई आप अभी ले जाइए, जो भी फॉर्मेलिटी कंप्लीट करके लाइए। लिमिटेशन को हमें बड़े ध्यान से देखना पड़ेगा, हमारे राइट इन्फ्रिंज हुए हैं, वहीं से पोजीशन अराइज होता है, उस चीज़ को भी देखना पड़ेगा। इसके साथ साथ कोर्ट फीस का कैसे कैलकुलेशन है वो भी क्लियर होनी चाहिए। जूरिडिक्शन दो ही प्रकार के, टेरिटोरी और पेकुनियरी। टेरिटोरी का मतलब है वेयर द प्रॉपर्टी सिचुएटेड विद इन द जूरिडिक्शन ऑफ द कोर्ट वेयर वी आर गोइंग टू फाइल। तो मैं इन्हीं शब्दों के साथ अपने छोटे से जो भी है वो करता हूँ और सर से आग्रह करता हूँ, हमारे जो अमले स्पीकर हैं।
बहुत अच्छी बात रखी अपने जयशंकर जी, बड़े संक्षिप्त में बोले। सोच रहे थे कि जी उन्होंने बोलेंगे सिविल में, नहीं, मैं बोला जी हमारे कंसल्टेशन रूम के भी एक किसी को बोलना चाहिए, आपने दूसरे मामले करते हैं, तो फिर भी आपने यहाँ पे अच्छा बोला है। अभी दूसरे स्पीकर के पास जाने से पहले मैं और एक बात रखना चाहूँगा। हम लोग जब कोई सिविल सूट ड्राफ्ट करते हैं तो बेसिक्स क्या है, कुछ कागज क्लाइंट आके देंगे, उस कागज को हमें एक के बाद एक तारीख वाइज हम रखते हैं, मतलब जिसको हम कहते हैं कि क्रोनोलॉजिकली हुए फिक्सिंग दो पेपर, उसकी फिर उसको आपने क्रोनोलॉजिकल लिस्ट ऑफ डेट्स भी बनाते हैं। उससे आपकी जो डिस्प्यूट से मोरलेस आपको पता चलता है कि आपको किस एंगल से इस केस को ले जाना है। अभी इन्हीं डॉक्यूमेंट्स को आपने अपनी प्लेंट में ही लिखना है। जब आप उसको प्लेंट में लिखते हो तो एक एक डॉक्यूमेंट की रिफ्लेक्शन आती है जो आपकी एविडेंस के साथ भी जाता है, जिसको आप जिन डॉक्यूमेंट को एग्जिबिट भी बाद में होता है, यदि वो मान गए, नहीं माने तो फिर उस डॉक्यूमेंट का हमने नोटिस टू प्रोड्यूस भी करते हैं यदि वो लेटर उनके पास से आया हुआ। तो ऐसे कई विषय भी है जो कि अपने आप में देखें तो प्लेंट की ड्राफ्टिंग भी, जैसे अभी थोड़े टाइम पहले आपने भी बताया कि एक आपकी कॉज ऑफ एक्शन है, लिमिटेशन है, आपकी जो आपकी क्या बोलते हैं जुरिडिक्शन है, ये जो है बेसिक से आप एक प्लेंट है। अब इन बेसिक बातें तो सारे जान गए, मगर अभी जो ऊपर की बातें हैं कि जो हायर पेडेस्ट्रल में कोई सिविल सूट को लड़ना है, उस विषय को भी जानना है। देखिए आज हम लोग कोई इंटरलोक्यूटरी एप्लीकेशंस के ऊपर नहीं रखे, हमारा सिर्फ एक सिविल सूट का प्लेंट की ड्राफ्टिंग, रिटन स्टेटमेंट, एप्लीकेशन तक वो बात हो सकती। तो आज हम सुनेंगे हमारे बीच में इन क्षेत्र से बड़ा अच्छे नाम कमाने वाले हमारे दिल्ली हाईकोर्ट से अशोक गुरनानी जी हमारे बीच में, वरिष्ठ अधिवक्ता। हम उनसे सुनेंगे, आपकी मार्गदर्शन रहेगा, बहुत अच्छा रहेगा।
Thank you, sir. The respected members of the organizing committee, my very estimated brother, Mr. Singh, all the members of the bar. Now, basically, I have been called upon to clarify the issue regarding the maintainability of the suit. The maintainability of the suit, among others, is related to Order 7 Rule 11, that is the power of rejection of the claim, are under the inherent powers of the court, where the Honorable Court can also reject a claim even if the ingredients of Order 7 Rule 11 are not attractive. Now, I have divided this into 2 or 3 parts. First is the assertion that with a view to make your plaint not being rejected, you must assert in the plaint the ingredients or the basis of your right to sue. Now, for example, if you are filing a suit under Section 6 of the Specific Relief Act, which is related to the issue of disposition, the first thing which you should do is to read the section. Please see what are the ingredients of that right. Disposition without your consent and without due process of law. So your plaint must say that I have been dispossessed without my consent and without due process of law. If you say I have been dispossessed, this plaint discloses no cause of action as far as Section 6 assertion or right is concerned. Apart from reading the law, please read the case law. If there is any interpretation to section 6 which gives a different color, expansion to section 6 or any particular law, or there is any deletion, subtraction, your plaint must be in consonance with the law and case law. And the most important thing which I think has to be concentrated is that your plaint must say what you have to say, and it must say what you are required to say, and it must say what you want to say. Please do not leave the plaint on implication or inference. You say this sentence from this kindly infer this. The honorable judge may infer or may not infer. He may go with your implication or may not go with your implication. So whatever is to be said, you say in express words. Now the second part comes, which is the negative part. That where a plaint can be rejected. A plaint can be rejected where you have a right, but your forum is wrong. Now, Delhi Land Reforms Act, Administrative Tribunal Act, there is a right. But partition suit, where DRR is applicable, would go to a revenue assistant. If you file a suit in before the Honorable High Court, the plaint would be rejected. So you have also to see, apart from your right, which is the correct forum. Choose the correct forum. Then comes the question of limitation, because limitation has been given under Order 7 Rule 11 specifically. Now if there is a suit on which there is no issue of limitation, suppose I borrow money from you tomorrow and file a suit day after tomorrow, no question of limitation will come. But there are many cases where the issue of limitation is not clear on the face of it, or it is a grey area. Like agreement to sale, 2 ingredients, defined date or when refusal. So if you are coming on refusal, please devote sufficient time to specify when there is a refusal, how there is a refusal, and apart from that, your plea should be supported with the documents which you are filing. There should be a consonance, not that you say one thing and document says other thing. Then comes the issue of relief. You should only ask that relief which is within the 4 corners of the forum and within the 4 corners of your right. If you ask for a relief which is outside the forum or outside your foundation of case, then also it is a case of rejection of the plaint. So the body of the plaint and the relief you are asking, there should be 100% consonance. Then apart from that, I request that when you are drafting a plaint, please have a full glance over the matter till the final. What document you would be able to prove, what evidence you would be able to lead. Now you draft a plaint in a very good manner, but no evidence, no document. That also makes the plaint faulty. It may not make it faulty technically, but ultimately that suit is liable to be dismissed. So you must concentrate. Have a proper interaction with the client, because client knows the fact. So you get the best fact extracted or known from the client, which you should put in plaint and plead and prove. If it is a case of territorial jurisdiction, if it is a clear, no difficulty, but sometimes it is not clear. There are again grey areas, exclusion clause, non-exclusion clause, where the cause of action has arisen, how the honorable court has the territorial jurisdiction. So where there is a gray area, give sufficient attention to the territorial class also. If you are playing territorial jurisdiction or it is delayed for a very long time on a territorial jurisdiction, that also defeats the purpose to a great extent of filing the suit and dismissal. So my one line is this, that before drafting and finalizing the plaint, read it 3 times. Try to see what questions are likely to be asked by the honorable bench. You should be ready with those questions beforehand, and your pleading must deal with those questions beforehand. So whenever a question is asked, you don't see here and there and make a request to the honorable court to read that paragraph, which you can read promptly. Expression should be clear. That's all. Thank you very much.
Civil suit is a huge area, and we are only giving some 20-30 minutes or 10 minutes. Sir is master on that, so is the case of Sir Honorable Senior Advocate Ashok Kumar Singh. Before that, I will also thank that some of our good people are also with us. Ajay ji is here, and many of lawyers are with us today, to whom we are also finding their studies. So I think everybody is taking also interest into that, and I think it is also quite learning kind of process for each and every lawyer, whether you are practicing in criminal side, company side, but have to have also the knowledge on other sides. So with that, I will now request our chief speaker, the chief guest, I will say Ashok ji, to have his feelings on this.
When Sudhir came to me, my friend Mr. Gurnani, my brothers here, Prashant and all friends sitting over here. When Sudhir came to me, I told him that as far as civil suits are filing with concern for the last 15 years, then I was designated speaker and so that I am not used for that. But there are certain problems which I, during the course of my practice, I have observed that normally the lawyers are not taking care of, and which are resulting into the litigation, appeals, revisions. And secondly, if they are taken care of, probably we can prove our case in a better manner, or we can defend our case in a better manner. One of the issues came before us when a court was not issuing summons, and the suit was filed. And the plaintiff was of the view that I filed the summons should be issued. Now the issue was whether summons should be issued in each and every case. Then we studied and then we realized that there are so many things which we have to understand before filing the suit. Every plaint which we file, the judge is not bound to issue the summons. Section 26 CPC says that suit shall be instituted when the plaintiff is presented. But how the plaintiff is to be presented? Then we have to go to order 4 rule 1. And when we go to order 4, rule 2, it says the plaintiff should comply with the provisions of order 6 and order 7. Then it will be deemed to be duly presented. So what is the requirement of the law is that whenever you are preparing a plaint, kindly see whether it is in compliance with order 6 and order 7 or not. Once you do it, you present a plaint, then you can make a request to the Honorable Judge that kindly look into it. It is duly instituted as per the provision of section 26 and as per the provision of order 4 rule 1. But if they are not complying with these provisions, then the judge has all the right to say, please I am not going to issue the summons on this plaint. It is not that while filing the suit you have to do it. When you receive a plaint also, as a defendant, is it not your duty to examine the plaint? That it is not duly stated or not duly stated? And when you examine it, find it is not duly stated, you can take it. Defense to that effect, you will testify. And irrespective of the fact that the judge doesn't issue the summons, then what is the position? This issue came before division bench in Delhi, when a judge refused to issue the summons, single judge, without disclosing, say, I am not happy with this. Then the issue was when discussed before the division bench, the division bench says that, look, though the word used in the order rule 1 and order section 26 CPC is made, but in case the plaint is in compliance with the directions or with the provisions of order 6 to 7, then those may should be here read as shall. The judge must issue the summons. These problems generally come when normally new counsel file the plaint and the honorable judge look into it and find that there is no compliance of order 6, order 7 and there is an objection. So it would be better that we should file the plaint, and before filing it we should see that it is coming within the parameters of order 4 and section 26, 27 of CPC. Second thing which I have realized is that order 2, rule 2 CPC we are neglecting every day. Very important provision. Order 2, rule 2 CPC is virtually if you have a cause of action which you have not taken in your plaint, then you cannot take it afterwards. Now when a client is coming to you, as my learned friend says that it is our duty that we should give sufficient time to the client. Try to find out all the facts which are given there. In one of the matters which came before me, when I was looking into the files, then I realized that about 10 years before filing the suit which was there to argue, another suit was filed by the plaintiff. It was suit for injunction only. The present suit was for suit for possession and declaration and injunction. The previous suit, it was an admitted case that the client knew very well, the plaintiff knew very well, the gentleman who filed the first suit, he knew very well that the illegal position was taken by our client. According to him, illegal position was taken. But at the point of time, he did not take the plea of position, he did not file for suit for possession or suit for declaration or anything. Then we took the defense that the second suit is brought by order 2 rule. And it is a very successful defense. So whenever a client comes before you, it is always better to ask each and everything. If suppose some litigation was started prior to the litigation which is there, must take papers of those documents, of that file, look into it and see if the facts are similar, and if you can take the defense of order 2 rule to please take it. Similarly, the position, sorry that I will not be feeling well. Similar would be the position, not filing. While after this, when you move further, what I have observed is that in amendment applications we normally move. Amendment is allowed also. When how the amended plaint is being filed? When this amended plaint is filed, 90% or more than 50% people, they commit the mistake. A full bench judgment is there, which has given the procedure how amended plaint should be filed. Whatever the amendment have been permitted, you have to mention that this is the original para, this has been amended, and after the amendment, this will be the new para. Normally, what happens? We file amended plaint, whatever is permitted, we just add it on, and it goes on. Now litigation goes on. The party takes objections that it is not as per the rules, High Court rules of judgment, and the matter goes on. If you look into the judgment of the full bench in this aspect, which was passed long back, we will understand how the amended plaint should be filed. So most of mistakes which we commit in filing the amended plaint, normally we will avoid that. One problem which I have realized was there when Order 7 Rule 11 application we normally file. Order 7 Rule 11 application is dismissed. What is the remedy available? There are instances which came, the parties filed the appeal under CPC. There is no provision in CPC. There is provision for file the appeal under order, if there is application under Order 7 Rule 10 or under Order 7 Rule 10, some order is passed and appeal is maintainable. Or for 711, what is to be done? Previously, the law was that in case it is so, then you can go under Latent Patent Act. Division Bench of Delhi High Court has done it. But subsequently, the matter came before the full bench. And the full bench examined the Later Patent Act as well as Delhi High Court Act. And it was decided that Order 7 Rule 11 CPC, application if is dismissed, it can be challenged only under Section 10 of Delhi High Court Act. So number of appeals which I have seen in High Court which are normally filed, this objection is taken, and sometimes even if the judges are not knowing that it is under Section 10 maintainable, they are filed in CPC, objection taken, they are dismissed, then the lawyers plan to go to Supreme Court for filing SLP without looking into provisions. If some precaution is taken, then probably this sort of problems can be meet out. But in any case, in Commercial Courts Act, no appeal is maintainable. I have seen in Commercial Courts Act also, in Order 7 Rule 11 application is filed or dismissed, then normally the lawyers advise that you file the appeal, we will do this thing, we will do that thing, but it is not maintainable. There is specific part of Section 8, so that is not to be there. So these small things that we take in, keep in our, notice at the time of litigation, only we can do much better in the courts, and we can avoid lot of unwarranted litigation and lot of unwarranted expenses of the clients which we normally, they spend on our wrong advice. There are some small points which I said that I will definitely share with you. Remaining next time, because time is not very short. Thank you very much. Thanks to everyone.
With such a small period, because it is 1 hour time only, and with that we have to complete many things. And civil suit is a very vast subject, as everybody knows. I think our team will be also deciding that to have one more also lecture on this civil suit, because civil suit on various aspects, be it is on the recovery part, be it is on I can say that on specific relief, many things are there. So with that, I will now request our friend Mr. Sudhirji to give his vote of thanks.
Before Sudhir speaks, my learned friend speaks, better you join, because Delhi High Court is using the decision of civil courts. There is a proposal that 20 crore up to 20 crore the cases will go to district court. So as we are sitting over here discussing civil suit, please take it granted that even 20 crore rupees case, normally senior advocate doesn't get. The client has to choose a lawyer who can tackle the matter of 20 crore. It is a good amount. Ashok Gundani may get, other friends may get some cases, but new lawyer, nobody would have the faith to have the matter of 2 crore, even 2 crore, 1 crore rupees to the new lawyer. So join hands, and our bar has taken some action so that this jurisdiction should not go to district court, should remain with the High Court. Plenty of matters will go. You people will not have the experience in the High Court on the original side. So better to join the hand with the bar association and see that this jurisdiction should remain here, so that few people go on learning a lot of things over here. Otherwise, you will have to shift to district courts. All of you will have to district courts.
Thank you very much. Now I must say that if there is a scope of CPC so much wide, then so much are the stalwarts who know how to tackle the issues of CPC. I must from all my team members, especially Prashantji, Nandita, Nazim, KK, I must thank these two stalwarts. Honorable Shri Ashok Kumar Singh Sahab, senior advocate, he was my guide, he was my mentor, he was a senior. Many times I had spoken to him on various issues. But let me say why Ashok Kumar Singh ji is a great stalwart. It is not just a civil issues. Ashok Kumar Singh Sahab is also very much well versed and a known name for arbitration issues, white collar crimes, and various criminal matters of huge capacity. And I know the kind of cases in PMLA and other UAPA cases Sir is actually taking care. And Sir is not only seeing these arguments in Delhi High Court, but he's a stalwart for Supreme Court of India. I must appreciate for Ashok Kumar Singh Sahab to tell us on the issue of summons, to tell us on the issue of 711 and what is the other remedy after 711. So all the advocates must take time. They must read what the Honorable Senior has said today. Thank you very much, sir, for your kind time, sir. Kind of you. Now, a very humongous stalwart. The name is synonymous with CPC, the procedures, the courts, Ashok Gurnani Sahab. Now, there is a very important judgment that was passed in Honorable Delhi High Court, and please correct me, sir, if I am wrong somewhere. That was Kamal Kumar Newar versus Nand Kumar Newar. That was a 2010 judgment. And Honorable Sir was the main counsel in that case. And why that judgment is synonymous? Because that judgment actually leads to on issues of substitutions of LRs and various applications. Honorable Sir was the stalwart who is actually synonym with Order 22 Rule 4. You people please understand why LRs issues and how to maintain the petition when LRs are introduced. See this judgment, 2010 judgments, Kamal Kumar Newar versus Nand Kumar Newar. This is 2010 judgment. If you people will read it, you will see the kind of chronology that has been given that judgment, and 99% what the learned sir has said on the dais, that thing is actually recorded in that judgment. So I'm so grateful that Gurnani Sahab has actually taken some time on very short request. Kind of you for your time, sir, kind of you. Now my very learned friend Jai Shankar has said very important thing. Why a civil suit should be initiated? Why a civil suit be filed? Definitely if it is infringing your civil right. So what are the civil rights? Is every right is a civil right or constituted from a civility of an origin of action? Then what important thing comes is cause of action. So Jai Shankar, that was a wonderful part from your side. I'm so grateful to you. And then my learned friend, very great friend, Rashid has said two things. Apart from the issues, apart from all the plain, what are the documents, especially the part 3 that you have stated? That part 3 is the most important. You don't know your document, you will not speak to your case. You don't know what is your document are saying, you will not reveal the kind of evidence that has to be said over there. So please, learned friend, the people who have attended today, but what these two stalwarts and two learned counsels have stated, you must get benefit from it. And thank you very much for this evening. Thank you very much, all of you that have taken time. And I request all of you for some tea and refreshment to the other side of the dais. Thank you very much.
अरे तो लंबा कर दे माता काम
investigated to the district.
Very question. ईटा से
सर ये स्टॉप कर दो सेफ के साथ